Welcome back to the channel, everybody. I'm Megan Fox, your favorite medium smart journalist. And today we've got a 51-page document from the Arizona bar destroying David Gingras and his behavior in the Laura Owens case. Let's go. All right, folks, gather round, because this is what we've all been waiting years to see. We were all wondering, how many bar complaints does it take before the Arizona bar gets off its ass and does something about the psycho they have running around with a bar license called David Gingras? Yes, that's right, David Gingras. He represented Laura Owens, the pregnancy faker. You know her.
It's douche canoe and pregnancy faker.
Yeah. The famous douche canoe lawyer. I even have a little douche canoe lawyer in a canoe back here just for David. He is one of the worst lawyers I have ever seen. I don't believe that Laura Owens would be facing 14 felony counts if it weren't for David Gingras. That's how bad of a lawyer I believe he is. And I think that that opinion is shared by a lot of people in the legal commentary space who have been following this case. Well, now finally, we have the Arizona bar and their charges against him. It has taken a very long time, folks. I mean, a very long time to get this. So buckle in. It's 51 pages. I'm going to try and get through all of it. And if I do it in record time, maybe we can get to his response. Let's see. Let's take a deep breath. Let's go. Introduction. And this is, by the way, the amended complaint made against the respondent, and the respondent is Gingras. Respondent represented Laura Owens in Maricopa County Superior Court regarding a motion for sanctions filed against her in a paternity case she had filed. And of course, it was a complete disaster of a case. Stephen called me a dumbass. After being hired by Owens, respondent became aware, based on his investigation and research, that she had made contradictory statements about her actions and had altered at least one medical record. Oh, yeah. She did. Despite being aware that Owens had given contradictory versions of events and altered at least one medical record, respondent failed to withdraw as counsel for Owens, or alternatively, failed to diligently investigate and research relevant facts, pursued claims that were without merit. Oh boy. Prepared an affidavit for Owens to sign that included false information. Failed to take steps to address false statements that Owens made during her deposition in 2 hearings, and presented Owens' false testimony to the court. And what false testimony might that be?
I've done nothing except get pregnant by the fucking Bachelor!
Yeah, that's right. During the period of representation, respondent failed to comply with a court order directing him not to disclose outside of counsel for the parties any medical or other documentation, exhibits, medical records, etc. disclosed between the parties. Oh, yes. Yes, she did. In fact, you know what I would like to insert here is the judge actually giving that order. I can pull that up pretty quickly because I remember it was the February 14th hearing with Corey, what's his name?
Record either, but my client does have a patient. She has privileges that in this case are not only being not considered or not fully considered, but it's being taken even further, and her documents are being, I have no doubt that the second we send over that disclosure statement by the end of the week, all of her records will be on Reddit. And so, Your Honor, I don't believe that I understand where the court is coming from. And I think that had there been some sort of an agreement, we've offered for the documents to be shared between counsel. I've offered for him to come to my office and see the documents. And we've had some discussion about that. Obviously, the recent pleadings, I think, may change that from the court. But it's not us trying to hide the ball. It's us trying to make sure that my client's medical records aren't shared with the entire world.
All right, we'll have the minute at agree reflect that no party is to disclose outside of themselves any medical or other documentation disclosed between the parties. That goes both ways.
Here it is.
I don't want anyone releasing any exhibits, medical records, or anything else regarding the other person. And that goes both ways, and truthfully should go without saying, but I recognize it does not in this case. I am going to order.
Yep. So I don't know how much clearer she has to be. I don't want anyone releasing anything. No medical records, no exhibits. And she put that on the order.
That the records be disclosed dating back to August of 2020. That's 1 year.
And nobody's allowed to share anything. Yet, Jingy, in his infinite wisdom, decided to immediately share, as soon as he got on the case, Laura's medical records, the same records that the judge just said don't share. All right, let's go back to here we go. All right, go back to the document. During the period of representation, respondent, put me down in the corner. I don't like being over here. Respondent took steps to prevent Michael Maricini, a potentially adverse witness, from appearing and testifying at a hearing held on June 10th, 2024. During the period of representation, respondent made public disparaging remarks on social media about members of the public and Maricopa County Superior Court Judge Julie Mata, who presided over the paternity case filed by Owens. During the period of representation, respondent filed and pursued a non-meritorious appeal. So those are all the things they're going to go after him for. Count 1, on August 1st, 2023, Laura Owens filed pro se a petition for court order for paternity and legal decision-making, parenting time, and child support against Clayton Eckert in Maricopa County Superior Court. The petition for court order of paternity alleged that Owens had become pregnant by Eckert. Where's my button? I need the button.
I have done nothing except get pregnant by the fucking Bachelor!
Owens attached to that expedited motion to seal court record copies of several email messages from Eckert to Owens in which he sought evidence that she was pregnant. Eckert asserted in email messages that Owens, A, was not pregnant by him, B, had never undergone an ultrasound, C, had offered illogical excuses to delay testing, and D, had provided him with a sonogram that had been created from an image on the internet. Among the email messages attached to the expedited motion to seal court record was a July 25th, 2023 email message from Eckert to Owens, which reflected that Eckert believed that Owens had provided him with a false sonogram. Yep, she did. Owens' September 14th expedited motion. I love how they keep repeating the way she does it. Expedited in quotation, or not quotation, parentheses, exclamation point, close parentheses. What? Motion to seal court record and other documents in the court record, including Eckert's email messages to Owens, placed respondent on notice that he needed to be diligent in ensuring that Owens was truthful about her health, alleged pregnancy, medical records and events, and B, determining whether any legitimate evidence existed reflecting that Owens was pregnant and that Eckert was the father. Okay, so in order to do that, by the way, it would be very, very simple. Let's discuss how an attorney coming into this case would have acted correctly. All right. Here's how David Gingras could have done this as an attorney who was responsible and ethical. You come into a case like this, you see the record. The record reflects that there's all this back and forth, he said, she said, about whether or not this chick is pregnant. This is very simple. You say to your client, sign this HIPAA form. I need your medical records from the doctor. And if you won't give me that, I'm out of here. And if she did give him that, and then he goes to the OBGYN and finds out not only is she not pregnant, but she's never even been to any of the appointments that she set, it's done. It's over. There's no case here. And you leave. Like, you don't take the case. He had a duty to do that. He had a duty to find out if she was pregnant or not. It's that simple. It's absolutely ridiculous what he has done in this case. It's ridiculous. And the bar is correct in holding him to account for it. Respondent had a duty to diligently investigate and research everything that Owens told him or provided to him. So if she hands you a sonogram with her name on it, you say, I'm sorry, Laura, but that's not good enough. What doctor did you get this from? And I need a release so I can get it from the doctor. It's that simple. Respondent Gingras failed to diligently investigate and or research Owens' allegations to determine whether her statements to him, opposing counsel in the court, were truthful, or that the sonogram provided to him and used during a court hearing on June 10th, 2024 was an image created by an ultrasound performed on Owens. On January 3rd, Eckerd's counsel filed a motion for sanctions pursuant to Rule 26 of the Arizona Rules of Family Law Procedure, in which he requested that Owens be sanctioned for filing the petition for a court order for paternity and later documents for an improper purpose and without medical evidence to support the claim that she was pregnant. Eckerd's January 3rd motion for sanctions pursuant to Rule 26. Oh, God, not Rule 26. Where's my button?
Hey, Rule 26 one more time, motherfucker.
Placed respondent on notice that Eckerd had claimed that Owens was not pregnant, which created a duty on his part to ensure that his investigation and research thoroughly addressed everything that Owens told him or provided to him. You remember every time we would call him out on something that he didn't know or was just pretending he didn't know, he would say, "Well, that was before my time." There is no such thing as before my time when you're an attorney with a case. You're supposed to research the case before your time. All of it. On February 21st, 2024, Judge Mata issued a minute entry order scheduling a hearing in the paternity case on June 10th, 2024. I was there. It was a good time to address the issue of sanctions and attorney's fees related to the paternity case filed by Owens. On March 11th, 2024, Eckerd's counsel filed a motion to compel, which stated in part that Owens had testified at her deposition that she had altered a sonogram falsely claiming it came from Southwest Medical Imaging. Yep. Based on the March 11th, 2024 motion to compel, respondent was once again placed on notice that he needed to be diligent in A, ensuring that Owens was truthful about her health, alleged pregnancy, medical records, blah, blah, blah. He's supposed to make sure she's telling the truth, and determining whether any legitimate evidence existed reflecting that she was pregnant and Eckerd was the father, which we all know there was none. During or about March 2024, Owens hired respondent to represent her regarding the motion for sanctions pursuant to Rule 26.
Hey, Rule 26 one more time, motherfucker.
On March 25th, respondent filed a notice of appearance on Owens' behalf in the paternity case. Upon agreeing to represent Owens, respondent had a duty in preparing her defense to the motion for sanctions pursuant to Rule 26.
Hey, Rule 26 one more time,
And represent her at the June 10th, 2024 hearing to A, diligently investigate and research both parties' assertions and documentation, B, carefully review the entire court record in the paternity case and not just say things like, that was before my time, and related cases between Owens and Eckerd. C, review the file provided to him by Owens' former counsel. And D, review the information and documents provided to him by Eckerd's counsel. Review other information that came to his attention. Like, you mean other information? Like when we would tell him on Twitter that how she was lying and he would just block us? Oh. On March 26, Eckerd's counsel filed a motion for relief from judgment based on fraud in the matter of Owens v. Eckerd, an order of protection case. That March 26 motion for relief from judgment stated in part, on October 6, 2023, and October 25, 2023, plaintiff Owens committed fraud when she filed her underlying petition for order of protection and then testified before Judge Duty. You remember him, Judge Duty. Just can't see the screen properly. Under the fraudulent pretense that she was pregnant with defendant Eckerd's twins. And that defendant Eckerd was cyberbullying her by posting her medical records. I like that. All the sarcastic quotation marks are making me laugh. Online. To be clear, plaintiff Owens was never pregnant by defendant Eckerd, as they did not have penetrative schmexual intercourse. Yikes.
I have done nothing except get pregnant by the fucking Bachelor!
That motion for relief from judgment further stated that Owens had admitted during her deposition that she had modified the medical records, which the court relied upon to grant an order of protection. Yep, she sure did. That motion for relief from judgment noted that Owens had provided no verifiable medical evidence to support her alleged twin pregnancy and had admitted that the ultrasound at the core of this court's basis for granting the protection order was de facto fraudulent. That motion for relief from judgment contained additional information relevant to the paternity case. That motion again placed respondent Gingras on notice that he needed to be diligent in all of those things, making sure that she was being truthful about all of these things, determining whether any legitimate evidence existed. But did he do those things? No, he did not. He did not do those things.
It's douche canoe and pregnancy faker.
Yeah.
Mm-hmm. On April 9th, 2024, respondent filed a notice of appearance and notice repending motion on Owens' behalf in the order of protection case. On April 22 and May 9th, respondent provided Eckerd's counsel with supplemental disclosure statements that failed to adequately address Owens' changing versions of events. On June 10th, Judge Mata presided over a hearing to address Eckerd's request for sanctions and attorney's fees. And that is a really fun court case. If you haven't seen it, it is on Schnitzel Ninja's channel. You can watch it. During the June 10th hearing, Owens provided false testimony about matters pertaining to her alleged pregnancy. Yeah, it was pretty epic. Respondent failed to correct or clarify Owens' false testimony during direct examination or redirect examination. Not only did he fail to do that, but he was giving her baseball signals. Like he failed to do anything that he was supposed to do. You can't signal your client when she's on cross, but he did. On June 18th, Judge Mata entered an under advisement ruling regarding the June 10th hearing in which she found that Owens failed to meet the burden of clear and convincing evidence that Eckerd was the father of Owens' alleged pregnancy. Owens acted unreasonably when she initiated litigation without basis or merit. The petition for court order for paternity was premature at best. Owens repetitively failed to comply with Family Law Rule 49 regarding disclosure, even on order of the court. Then we have a footnote. The under advisement ruling did not specify the disclosure violations other than to state that Owens presented new information about an ultrasound at the hearing and testified on the day of the hearing that she anonymously sought care at a Planned Parenthood location in Los Angeles, which had never been disclosed. Judge Mata did not find that respondent had failed to comply with the disclosure or discovery rules or the court's April 4th, 2024 order compelling disclosure. Owens acknowledged that she altered HCG test results. Wait, we have another one? Yep. An HCG test is a medical procedure used to detect pregnancy. We all know that. Okay. And an ultrasound and sonogram. Is that just going to be a definition of what it is? Yes. Okay. Everyone knows what it is. The petition was not filed in good faith. The petition was not grounded in fact or based on law. The petition was filed for an improper purpose, such as to harass the other party, to cause an unnecessary delay, or to increase the cost of litigation to the other party. Owens provided false testimony as to the viability of the pregnancy in the paternity case, the order of protection case, and an injunction against harassment case filed by Eckerd. And Owens knowingly presented a false claim and knowingly violated a court order compelling disclosure or discovery such that an award of attorney's fees and costs is appropriate under ARS 25-415. As you can see, not Rule 26.
Say Rule 26 one more time, motherfucker.
On August 16th, Judge Mata issued an order application for attorney's fees and costs, directing Owens to pay a total of $149,000, $219.76 in attorney's fees and costs to Eckerd within 180 days. Respondent violated Judge Mata's February 21st order. All allegations set forth above are incorporated herein. Okay, got that. Let's move on. On February 21st, which I already showed you, Judge Mata issued a minute entry order in the paternity case regarding the status conference held on that date, which stated in part, it is further ordered, denying counsel for petitioner Laura Owens' oral motion to reconsider regarding the ruling concerning petitioner's motion for confidentiality. Further discussion is held regarding discovery and disclosure. Counsel for petitioner Owens addresses the court with an oral request to have the court order his client provide medical records pertaining to the pregnancy only. Let the record further reflect that no party shall disclose outside of themselves any medical or other documentation, exhibits, medical records disclosed between the parties. It is further ordered that the records be disclosed dating back to August of 2020. On April 1st, respondent filed a motion for extension of time to respond to respondent Eckert's motion to compel, hereafter motion for extension of time to respond, to which he attached a declaration that he signed. Respondent included the following in his April 1st motion for extension of time to respond: a reproduction of a portion of Owens' lab results history dated June 1st, a portion of an unable to process request notice from Banner Health regarding Owens, and C, a portion of a receipt from Banner Urgent Care regarding Owens dated June 21st, 2023. Respondent included the following in his April 1st declaration: A, a reproduction of a portion of Owens' lab results history report dated June 1st. All right, so he put all these medical records out there. We don't need to read every single one of them. Copies of messages between Owens and Dr. Joshua McCool, no more stuff from Banner. Respondent knowingly violated Judge Mata's order. And here's how we know he knowingly did it. We told him. We all told him. We were like, dude, why are you doing this? And it wasn't just us. You're going to find out in this thing that Greg Woodnick told him too. And he still didn't do anything about it. He didn't take him down. Respondent failed to file a motion to seal either his April 1st motion for extension of time or his declaration, despite Judge Mata's February 21st, 2024 minute entry order. On April 4th, respondent posted the following on his law office blog. It was a great idea to start that blog, David. It's just a fabulous idea. On October 16th, Laura had a blood test done at a lab. Want to guess what the results showed? Pregnant. But don't take my word for it. The report can be viewed right here. The underlined text was a link to Owens' October 17th Sonora Quest Laboratories medical report. Respondent knowingly violated Judge Mata's February 21st, 2024 order by including a link on his blog that led to Owens' October 17th, 2023 Sonora Request Laboratories medical report. Also on April 4th, Greg Woodnick, Eckert's counsel, this is something we hadn't heard before, sent an email message to respondent which stated in part, I am also not certain why you are publishing court documents on your client's personal medical records contrary to a court order. Laura Owens needs to comply with the order and provide disclosure. So Attorney Woodnick put him on notice. That email message from Attorney Woodnick placed Gingras on notice that he needed to take some action to seal Owens' medical information and documents. Because if Clayton had done that, you know damn well he would have filed for sanctions based on judge's order. But Laura can do it. Unbelievable. Despite notice from Eckert's counsel regarding his violation of Judge Mata's February 21st order, respondent failed to file a motion to seal Owens' medical information and the documents that he disclosed. On or about April 19th, respondent posted on his law office blog and or other social media the content set forth in Exhibit A to this complaint, which included a portion of one of Owens' medical records. On April 26th, a Friday, at approximately 5:52 p.m., respondent filed petitioner's response to respondent's amended complaint or amended motion for relief based on fraud, hereinafter the April 26th response. Respondent's filing of the April 26th response did not, at the time he filed it, become a matter of public record. That April 26, 2024 response included a summary of portions of Dr. Dean's and Dr. Justicia Lynn's expert report, which they had prepared for Eckert, pages 8 through 11, under the heading Miss Owens was pregnant, discussed Dr. Dean's and Dr. Justicia Lynn's expert report, and a quotation taken from Dr. Dean's and Justicia Lynn's expert report appeared near the bottom of page 10. Attached to that April 26, 2024 response was a copy of Dr. Dean's and Dr. Justicia Lynn's expert report and Dr. Dean's curriculum vitae, whatever, her resume. That April 26, 2024 response discussed the report provided by Owens' medical expert, Dr. Michael Medchill. Remember him, the dribble before you shoot guy? Attached to that April 26 response was a copy of Dr. Medchill's expert report and curriculum vitae. I don't know how to say that. Also attached to that April 26, 2024 response were copies of Owens' medical records and other documents relevant to Eckert's claims. Owens' affidavit, dated April 16th, included information from Owens' medical records and portions of her medical reports and records. At approximately noon on Saturday, April 27th, 2024, a respondent posted on his publicly accessible personal X, formerly Twitter account, his law firm website and or other social media, a link to, among other things, his April 26, 2024 response, which included portions of Owens' medical information and documents. Respondent knowingly violated Judge Mata's February 21st, 2024 minute entry order by posting Owens' medical information and documents on his X accounts or other social media. On April 29th, the Maricopa County Superior Court Clerk's Office docketed respondent's April 26 response, at which time that document became a public record available to the public through the clerk's office. Neither Dr. Samantha Deans nor Faye Justicia Lind consented to the publication of their expert report because it contained a review of Owens' private medical records, which was intended solely for the attorneys and the court's review. At no time did respondent file a motion to seal Owens' medical information or documents or his April 26 response, despite Judge Mata's February 21st minute entry order. Oh no, David, this is bad. Ethical violations related to respondent's violation of Judge Mata's February 21st order. By engaging in the conduct set forth above, respondent violated ER 3.4c by knowingly violating Judge Mata's February 21st, 2024 order and court rules, by making extrajudicial statements that he knew or reasonably should have known would be disseminated by means of public communication, and that would have a substantial likelihood of materially prejudicing the paternity case. By using means that had no substantial purpose other than to embarrass, delay, or burden any other person. By knowingly violating Judge Mata's February 21st order. None of this sounds very good for him. Respondent's efforts to preclude Michael Maricini from testifying on June 10th. Oh boy, the witness intimidation portion of the show is just beginning. All allegations set forth above are incorporated herein as if set forth in full. Laura Owens obtained a domestic violence restraining order, DVRO, against Michael Maricini in California, which was renewed and extended to September 11th, 2025. And that was a full of shit order that was fraudulent and totally bullshit. She should never have gotten it, but the courts, you know what the courts do. That DVRO required Maricini to remain at least 100 yards away from Owens. During the course of the paternity case, Eckert's counsel disclosed to respondent that he intended to call Maricini as a witness. A few weeks later, just before the disclosure discovery deadline, Eckert's counsel informed respondent that contrary to information respondent, had been given by Maricini's California attorney, Maricini would appear and testify at the hearing. Neither Eckert's counsel nor Maricini nor respondent filed a motion in the San Francisco County Superior Court to modify the terms of the DVRO to allow Maricini to testify in Arizona. On April 30th, respondent filed a motion in limine, Gingras did, asking the court to preclude Maricini from testifying because A, his testimony would elicit improper Rule 404B evidence, and B, Eckert's counsel had allegedly failed to comply with the disclosure rules regarding the nature of Maricini's testimony. Respondent did not reference the existence of the DVRO in that motion in limine. Also, on April 30th, respondent filed an emergency motion to strike and request for immediate telephonic scheduling conference. Hereafter, emergency motion to strike, which included a request for an immediate scheduling conference to address whether Eckert's counsel would be permitted to call 3 newly disclosed witnesses, one of whom was Maricini at the June 10th hearing. On or about May 7th, Eckert's attorney subpoenaed Maricini to testify as a Rule 404B witness at the hearing scheduled on June 10th. Maricini was aware of the paternity case and agreed to voluntarily appear and testify in Arizona at the June 10th hearing. In an email message from respondent to Eckert's counsel on May 8th, Gingras stated, This goes without saying, but to the extent I suggested that Mike Maricini would be arrested if he comes to court in Arizona, that suggestion is completely and totally withdrawn. I only said that because I didn't want Mike to show up without giving me the chance to at least interview him, as I would with any normal witness. As long as Mike agrees to have a reasonable call to answer some questions, I'll stipulate and agree that his appearance in Arizona is not a violation of anything and will not expose him to arrest or other legal consequences. Well, how magnanimous of you, sir, to put your extortion in writing. Maricini did not make himself available for respondent to interview, nor did he need to, nor did he have any obligation to. On May 21st, Judge Mata issued a minute entry order denying Gingras' motion in limine. On June 3rd, to preserve the issue of the propriety of Maricini testifying at the June 10th hearing, Gingras filed a pre-trial statement that addressed that issue. In the pre-trial statement, Gingras explained that it would be a crime for Maricini to violate the California DVRO and that any violation of the order by Maricini would subject him to arrest. Oh my God, this guy is such a douchebag. That pretrial statement also stated that the issue has been reported to court security by the undersigned counsel, David Gingras, Esquire. God, where's my music? Who has requested that Mr. Maricini be arrested if he violates the DVRO as the law requires. Also, on June 3rd, respondent called security personnel at the Maricopa County Superior Court and spoke with Officer Gibbs, informing him that Owens had a valid DVRO from California and that she was concerned that he intended to violate the order by appearing at trial. Okay. Also, on June 3rd, respondent Gingras sent an email message to Officer Gibbs, to which he attached a copy of the California DVRO. Gingras' June 3rd email message to Officer Gibbs stated that court approval for Maricini to appear at trial has not been granted, and the DVRO contains no exceptions for in-person contact like this. Wait a minute. But but the judge denied the motion in limine, so she basically said, yes, he can. So this is a lie. Judge Mata had previously denied respondent's April 30th motion in limine, just like I just said, to prevent Maricini from testifying, but had not yet ruled on his objection to Maricini's testimony, which he set forth in a petitioner's pretrial statement. But isn't that the same thing? Isn't the motion in limine to keep out a witness? And she denied it. So she has to do it again for this guy? Whatever. Respondent also claimed in his June 3rd, 2024 email message to Officer Gibbs that if Maricini if he appeared in court, he would clearly violate the DVRO. Respondent Gingras additionally claimed in his June 3rd email message to Officer Gibbs that due to the short time before the trial, he cannot raise this issue with Judge Mata before next week. On June 4th, Eckerd's counsel sent an email message to Officer Gibbs and Judge Mata's court stating that a valid subpoena had been issued for Maricini's appearance. Gingras was copied on that email message. Eckerd's counsel, Woodnick, suggested that in that June 4th email message to Officer Gibbs that Gingras' act of requesting law enforcement to enforce Owens' DVRO qualified as an attempt to intimidate a witness as set forth in the law. Sometime prior to the June 10th hearing, respondent Gingras sent an email message to Maricini's California attorney informing her that because of the DVRO, Maricini would be arrested if he attended the June 10th trial. On the morning of June 10th, when Owens saw Maricini in the parking lot, respondent contacted court security personnel, Gingras did, but he was informed that they were unable to help. Sorry, dude. The judge already said he could be here. This is her kingdom. Shortly thereafter, respondent called 911 from the courthouse parking lot to report Owens' concerns about Maricini's ostensible violation of the DVRO. First of all, you have to understand that in the parking lot, you could see the bomb squad with the dogs. Like, what in the hell did he think Maricini was going to do to lure Owens with the SWAT team and the bomb sniffing dogs and the, canine unit and all the sheriff's officers who work in the court? Like, this is such garbage. Prior to the commencement of the June 10th hearing, court security personnel and or the Maricopa County Sheriff's Office informed the court that Gingras had called 911 from the parking lot of the Northeast Justice Court building and attempted to have Maricini arrested for violation of the DVRO. Judge Mata or a member of her staff through court security personnel and or MCSO informed the responding police officers that Maricini was responding to a valid subpoena and was not to be detained prior to his testimony. Yep, the judge had to step in and stop this fool. Again, imagine being poor Judge Mata. On June 10th, 2024, court security personnel escorted Gingras and Owens from the parking lot to the courtroom prior to the hearing. They sure did. I saw them. I was there. We were filming. I have pictures. At the June 10th, 2024 hearing, Judge Mata allowed respondent to argue on the record before any witness was called his objection to Maricini testifying. Respondent argued non-disclosure as a basis for precluding Maricini's testimony as well as the existing of the DVR, stating, "The second issue, Your Honor, deals with this California court restraining order. I think you have a copy of it. It's one of our trial exhibits. We have a court record from the state of California that prohibits Mr. Maricini from being within 100 yards of Miss Owens. He is in violation of it right now. There is no exception for court appearances. She, Owens, is so terrified that she may not be able to sit here during this trial."
What?
Under the full faith and credit clause of the U.S. Constitution and also under federal law, this court is required to enforce the order as is written. You can't change it. You can't modify it. You can't disregard it. And yet, here we are. Judge Mata affirmed her prior ruling allowing Maricini to testify. She was like, "That's nice. Sit down now."
Denied. Sit down.
Thank you for sharing that. Thanks for sharing that, baby Jingy. Thank you. But no, thank you. Maricini was sworn to testify in court on June 10th, but never testified because they ran out of time. Violations based on respondents' efforts to preclude Michael Maricini from testifying on June 10th. Based on the conduct set forth above, I'm so uncomfy. I've been sitting here a while. This is a long document. Based on the conduct set forth above, respondent violated ER 3.4a and ER 8.4a by unlawfully attempting to obstruct Clayton Eckert's access to Maricini's testimony by using means that had no substantial purpose other than to embarrass, delay, or burden Eckert or his counsel, and by engaging in conduct prejudicial to the administration of justice. He also wasted a hell of a lot of the court staff's time, including the sheriffs, the officers, the false 911 call. Like, he should be charged for that. All respondents' disparaging comments about Maricopa County Superior Court Judge Julie Mata. Oh boy, this is where it gets really bad, you guys. All allegations set forth above are incorporated herein as if set forth in full. Respondent knowingly made unprofessional, disparaging, and inappropriate comments about Judge Mata's qualifications and or integrity in documents filed with the court and in posts he made on social media accounts. First instance, Judge Mata's father's attendance at the June 10th hearing, which, by the way, has never been verified. He may not have even been there. It could have just been somebody saying it. On July 8th, 20 days after Judge Mata entered her under advisement ruling regarding the June 10th hearing, respondent filed a notice of change of judge for cause, memorandum, and affidavit in support. Hereafter, notice of change of judge for cause, which was unprofessional and inappropriately disparaging of Judge Mata. For example, respondent stated the following in the notice: "It is difficult to imagine a more disrespectful, disreputable, and disgraceful act for any judge to commit than inviting her father to attend a high-profile trial in support of a party, while also privately engaging in prohibited ex parte discussions about the case with her father." And we have a footnote. According to internet reports, Judge Mata's father attended the June 10th hearing over which Judge Mata presided and was present in the overflow courtroom where the hearing was live streamed. These actions made a mockery of these proceedings. As shown in the video clip submitted herewith, Clayton's supporters gleefully celebrated Judge Mata's father's participation in the case, even going so far as to laughingly ask people not to spread information about his participation because, after all, we don't need a mistrial here. That was Dave just making a joke. For once, those followers were exactly right. The conduct of Judge Mata and her father absolutely warrant a mistrial, or more accurately, a retrial before a different unbiased judge. That's false. Someone's family member just showing up and coming to a court case that you're presiding over is perfectly reasonable. Her father is a member of the public and he's allowed. All this stuff he said about him being there in favor of a party, that is not, there's no evidence of that. He could have just been there to watch. Which I'm assuming that's, if he were there, that's what he was doing. This shameful conduct by Judge Mata not only violated Laura Owens' rights, it raises serious questions regarding Judge Mata's fitness as a judge of the Superior Court. Any reasonable objective observer in Laura's position would be justified in wondering, was my case fairly decided based on the evidence, or was Judge Mata simply trying to impress her father? And now comes the sentence. That is the worst, most embarrassing, cringeworthy sentence to ever be put into a motion, which, when it was first read by Ian Runkle, who is also an attorney, he was so flabbergasted. He was like, oh my God, if I wrote something like this, I would just have to hand in my bar card. Like, you just take my license. Look at me, Daddy. I'm a real judge now. Just watch me destroy a young woman's life because the other party was on The Bachelor. Hee. Wow, David. Assuming the published allegations of Judge Mata are true, as documented on video by Clayton Eckert's own followers, this proves Judge Mata separately violated Rule 2.9a of the Code of Judicial Conduct, and Judge Mata's blatant, pervasive disregard for her ethical duties and her disrespect for Laura's fundamental rights helps explain the judge's numerous and otherwise heretofore inexplicable adverse rulings during this action. He was still butthurt that he got denied his motion to compel lunch.
Denied. Sit down.
Second instance, screwed up form of final judgment sometime prior to September 3rd, which was during the pendency of Owens' appeal from Judge Mata's under advisement ruling dated June 18th. Respondent posted on his law firm's or personal blog, X, formerly Twitter account, and or other social media, the content set forth in Exhibit B to this complaint. Respondent's comment above pertained to Judge Mata's inadvertent reference to an incorrect family law rule regarding the final judgment language in her June 18th under advisement ruling regarding the June 10th hearing. She referenced Rule 78B of the Arizona Rules of Family Law Procedure instead of 78C. She corrected that inadvertent error on February 18th, 2025, after the Arizona Court of Appeals remanded the matter to Superior Court. Third instance, commission of a crime. Sometime prior to September 3rd, during the pendency of Owens' appeal, respondent posted on his law firm's or personal blog, X, or other social media, the contents set forth in Exhibit C. Respondent's reference to Judge Mata committing a crime pertaining to her alleged failure to enforce the DVRO against Maricini by allowing him to attend the June 10th hearing and be within 100 yards of Owens. Well, wait, I want to see it. Where's Exhibit C? All right, we're on 23. Let's go to Exhibit C. He said, no, the judge committing a crime was completely unnecessary. See this text here. Me explaining how this made Laura feel was entirely necessary, legal, and ethical. I hope no judge ever violates your rights and treats you this way, but if they did, how would you feel? God, he's such a baby. Internet posting of public warning of Judge Julie A. Mata on December 16th. Respondent posted on his law office blog website the content set forth in Exhibit D to this complaint, which stated in part that Google is not a valid legal source of evidence unless your case is assigned to Judge Mata, ellipsis in original. Fifth instance, on December 10th, respondent recorded a podcast in which he stated the following. If Judge Mata was a person who cared about the rules, she would have sanctioned Eckert's counsel Woodnick for making a false statement about the law, and she could have referred him to the state bar like she did with me. Violations related to respondents' disparaging comments about Judge Mata. Frankly, I don't think that number 5 is going to matter. That's probably going to get dropped. I think you can say that. I don't think that was as disparaging as the rest of them have been. But that one's probably not going to go anywhere. This one, though, the public warning, that one looks pretty bad. And the commission of a crime one, that one looks pretty bad. But I would say this other one, this disparaging comment, just saying if she was a person who cared about the rules, I don't think that one is enough. Violations related to respondents' disparaging comments about Judge Mata based on the conduct set forth above. He violated all these rules by using means that have no substantial purpose other than to embarrass or burden Judge Julie Mata by making statements with reckless disregard as to their truth or falsity concerning Judge Mata's qualifications or integrity. All right, so unprofessional conduct, blah, blah. Disparaging comments about members of the public. This is another one that I think he'll get away with. I don't think there's any... I mean, I know that the rules say you shouldn't do this, but I think in his trial, they're going to end up getting rid of this one too. All allegations set forth above are incorporated herein. On November 21st, respondents sent an email message to Laura Owens and copyright at reddit.com in which he identified himself as a lawyer in Phoenix, Arizona, representing Owens in her case against Eckert. That November 21st email message, which respondent made available to Reddit employees when he sent it to their email address, stated in part, Clayton Eckert's fans are, generally speaking, total fucking psychotic assholes. Clayton's fans, being total fucking assholes that they are, have come up with a new plan. Yeah, he's going to get away with this one. This one is not, that's just a free speech issue. I really don't think that he's going to get dinged for that. On December 4th, respondent filed a request for subpoenas to identify infringers pursuant to whatever rule and supporting declaration hereafter request for subpoenas. Respondent included a copy of his November 21st email message as Exhibit A to that request for subpoenas. Oh, that's interesting. So he put it on the record. Well, that might be different then. Why would he do that? Why would he put that on the record? What a stupid thing to do. If he had just left it to his private email, it probably wouldn't have been a problem, but maybe it will because he put it on the record. Violation related to respondents' disparaging comments. By engaging in the conduct set forth above, respondent violated the rule by engaging in unprofessional conduct. Respondents' meritless claims, false information in an affidavit, and presentation of Owens' false testimony, changing versions of events. All allegations set forth. Yeah. Eckert's counsel deposed Laura Owens on March 1st, approximately 3 weeks before Owens hired Gingras. During Owens' deposition, she testified that she had an ultrasound performed at Planned Parenthood on July 7th in Mission Viejo, California, and B, altered the California Planned Parenthood sonogram to say SMILE for Southwest Medical Imaging instead of Planned Parenthood. C, had gone to Planned Parenthood anonymously. D, added her name to the sonogram. E, not changed the date on the sonogram from July 2 to July 7th, and altered the sonogram at home using Adobe Acrobat. On March 11th, Eckert's counsel Woodnick filed a motion to compel the production of, among other things, the original records from Planned Parenthood Mission Viejo Health Center. On March 25th, Jingras sent an email message to Eckert's counsel stating that he would take a trust but verify approach with Owens and that he would actively investigate every detail of what she had said, looking for information that contradicted her statements. On March 20th, he said that to a lot of us, didn't he? On March 27th, 2024, Eckert's counsel sent an email message to respondent stating that A, Owens' prior counsel had presented records to the court, including medical records and letters from law firms that were fabricated by Owens. B, Owens had misused court processes in multiple states to perpetrate the most bizarre of cons for relationships, and that's in quotation marks, I like that. And C, 4 men had documented Owens faking pregnancies and fabricating medical records. That March 27th letter from Woodnick placed Gingras on notice that he needed to be diligent in all of those things, ensuring what she said was true, verifying the evidence, etc. On April 4th, Judge Mata signed an order granting Eckert's motion to compel and directing respondent to provide Eckert with the following, among other things, by 5 p.m., April 19th, 2024. All medical records for petitioner Owens from Planned Parenthood Mission Viejo from on or about July 7th, 2023. That April 4th order placed Gingras on notice that he had to diligently search for all of Owens' medical records at Planned Parenthood Mission Viejo from on or about July 7th, 2023. And this gets so nuts right now. On April 10th, Gingras reviewed Judge Mata's April 4th order and sent an email message to Owens regarding that order. We've never heard this before. When respondent asked Owens for information about the Planned Parenthood sonogram, she provided him with her username and password for her Planned Parenthood patient portal. On April 15th, hey, my birthday, at 1:55 p.m., Gingras logged into Owens' Planned Parenthood patient portal. When respondent logged into Owens' Planned Parenthood patient portal on April 15th, records reflected that Owens had scheduled an appointment at Planned Parenthood in California under her real name, apparently in late June of 2023. Owens' Planned Parenthood patient portal also reflected an appointment scheduled for July 2 at a Planned Parenthood location in Costa Mesa, California, located in Orange County. Owens' Planned Parenthood portal did not reflect an appointment at a Planned Parenthood location in Los Angeles. Although respondent had checked Owens' Planned Parenthood portal on April 15th and knew it did not have records reflecting that Owens attended an appointment or had an ultrasound performed at the Mission Viejo location, Gingras never took any steps to correct Owens' false deposition or June 10th hearing testimony that her ultrasound was performed in Mission Viejo, or additionally, in the case of the hearing, Los Angeles. Oh my goodness. At some point in time, Gingras became aware that Woodnick had unsuccessfully sought copies of medical records pertaining to Owens from Planned Parenthood in Mission Viejo, California. Upon learning that Eckerd's counsel had not obtained records from Planned Parenthood in Mission Viejo, Gingras was on notice that he needed to be more diligent and more closely scrutinize what Owens had told him. Gingras was aware that Eckerd had alleged in his motion to compel that he, Eckerd or his counsel, had received confirmation from nearly all providers that Owens was never a patient of theirs. The motion to compel placed Gingras on notice that he needed to be diligent in all of the things we've already talked about, making sure she was truthful, determining what the evidence was and if there was any. Gingras learned prior to the June 10th hearing that Owens had not gone to a Planned Parenthood office in Mission Viejo, California. He also learned that she had not gone to one in Los Angeles. Prior to the June 10th hearing, Owens told Gingras that she had made appointments with Planned Parenthood in Southern California on 2 consecutive weekends, June 23rd to 25th and June 30th to July 2. Owens admitted to respondent, Gingras, that she had altered the sonogram prior to the date she hired him. On April 15th, Gingras sent a draft affidavit to Owens. This is unbelievable, guys. To review and sign, after which she informed him by email about some possible changes, including the following. Maybe don't include the ultrasound since I tampered with the top. I don't want Dr. Mitchell to question me and my credibility based on that.
She lied.
Mm-hmm. He still put it in. He put it in anyway. On April 16th, Gingras discussed with Owens the draft affidavit he had sent her on April 15th. Later on April 16th, Owens executed the affidavit that respondent had drafted and which was attached to the April 26th response to respondent Eckerd's amended motion for relief based on fraud. Owens' affidavit, a portion of which is set forth in Exhibit E to this complaint, included an image of the altered sonogram that he knew damn well was not taken in any Planned Parenthood, and he knew damn well she had tampered with because she told him. Respondent subsequently Gingras learned that Owens had allegedly gone to Planned Parenthood in late June 2023, but took no steps to correct that false statement in her April 16th affidavit. The sonogram that Owens claimed was from Planned Parenthood, shown above, includes her real name, even though the sonogram was not a sonogram that resulted from an ultrasound that had been performed on Owens. Owens stated in her affidavit and under penalty of perjury, however, that she had not changed anything on the sonogram other than the name of the facility and the date. During Owens' March 1st, 2024 deposition, she testified that she went to Planned Parenthood anonymously and that she later added her name to the sonogram.
What?
Respondent read Owens' March 1st deposition transcript on April 8th. Gingras became aware that Owens had falsely testified during her March 1st deposition that she obtained the ultrasound on July 7th, 2023. Owens told Gingras that she went to Planned Parenthood anonymously, and then later at the June 10th hearing testified she went to Planned Parenthood using a fake name. Based on respondents' review of the transcript of Owens' March 1st, 2024 deposition, Gingras knew that Owens either A, testified falsely at her deposition by stating she had gone to Planned Parenthood anonymously and subsequently changed the name of the facility and added her name to the sonogram, but did not change the date on it, or B, signed a false affidavit which he filed that stated she altered only the facility name and date. Respondent failed to take steps to address Owens' false testimony during her deposition or to address her false affidavit. Respondent never obtained from Owens the original unaltered sonogram that she allegedly obtained from Planned Parenthood in California. Respondent failed to verify. Gingras failed to verify with Planned Parenthood whether it treats people anonymously or people using fake names. Spoiler, it doesn't. On April 18th, Gingras sent an email message to Owens stating that he had told Woodnick that she went to Planned Parenthood on July 2nd, but that he had located an email message from her to Dr. Zeman dated June 28th stating that she had gone to Planned Parenthood the previous weekend. Oh, God. On June 3rd, Corey Keith, the attorney who represented Owens immediately prior to Gingras' representation of her, filed a notice of candor to the court. In that notice of candor, Attorney Keith stated that he told the court the following at a status conference on February 21st. Owens has not lied in this case. She has not intentionally lied to the court. Attorney Keith stated in that notice of candor that at the time he made those statements, he believed them to be true. Attorney Keith further stated in the notice of candor that based on Owens' March 1st deposition testimony, he no longer believed the statements he made on February 21st were true. Smart man. Attorney Keith summarized Owens' deposition testimony in that notice of candor. Attorney Keith included evidence in that notice of candor establishing that Owens had testified falsely before Maricopa County Superior Court Commissioner Cynthia Galkatsas several months earlier in Eckerd v. Owens, an injunction against harassment proceeding. Gingras failed to take steps to address Owens' false statement to Judge Galkatsas during the November 2 hearing on the petition for injunction against harassment. Attorney Keith also noted that in the notice of candor that Owens testified before Judge Galkatsas, among other things, that she had been seen by Dr. Higley last Friday, 40 minutes into the hearing, but stated that during her March 1st deposition that she had an appointment with Dr. Higley, but did not attend that appointment. At some point in time prior to the June 10th hearing, Owens admitted to Gingras that she incorrectly testified before Judge Galkatsas that she had just been seen by Dr. Higley last Friday, but in reality had only made an appointment to see him. Although Gingras was aware of the content of the notice of candor, he failed to diligently investigate and or research Owens' statements to him, which he presented to the court. Prior to June 10th, respondent reviewed transcripts and video recordings of prior hearings. Gingras did. Owens and Eckerd's deposition transcripts taken before Owens hired Gingras. The file maintained by Owens' second attorney, including documents he had prepared and filed. D, the report prepared by Eckerd's expert witness, disclosures made by Eckerd's counsel, the medical records provided by Owens, and possibly other records and information related to issues in the paternity case and related cases. Based on the information that respondent acquired during his representation of Owens, he was aware that Owens had testified falsely before Judge Galkatsas, made false statements during her deposition, altered a sonogram, which he offered into evidence during the June 10th hearing, and or D, signed an affidavit that included false information. Oh my God. Awful, which was filed with the court. Respondent knew Gingras knew that Owens had not been truthful about the facts material to the paternity case, but did not withdraw from the case or take sufficient steps to address Owens's false statements and the altered sonogram. It's a bad choice. It's a really strange choice, Jingy. During that June, how you doing, folks? You hanging in there? Because this is rough. It's a long one, but I'm almost at the end. You doing okay? During that June 10th hearing, Owens testified on direct examination that she obtained a sonogram at Planned Parenthood in California. Owens testified on direct examination she went to Planned Parenthood under a fake name, which was contrary to her deposition testimony that she went anonymously. Gingras asked Owens on direct examination if she changed the name at the top of the sonogram. Owens responded, of the location, yes. Owens testified on direct examination that the Planned Parenthood sonogram was obtained at the end of June 2023. Owens admitted during cross-examination that she had stated during her deposition that the ultrasound had been performed in Mission Viejo on July 7th. Owens also testified during cross-examination that she had been staying in Mission Viejo during or about late June or early July. Owens further testified during cross-examination that she had changed the date on the sonogram from July 2 to July 7th and that the July 2 date was the correct date. Oh my God, this woman. That testimony conflicted with her deposition testimony when she stated she had not changed the date on the Planned Parenthood sonogram and her testimony during direct examination that the ultrasound was conducted in late June of 2023. During cross, Eckert's counsel reminded Owens that during direct examination by Gingras, she testified that she went to Planned Parenthood under a fake name. During cross, Eckert's counsel informed Owens that the Planned Parenthood office for Orange and San Bernardino counties had submitted a letter noting that she had scheduled an appointment for July 2, but that appointment was canceled, and the ultrasound image she relied on, which she claimed to have obtained from Planned Parenthood in Mission Viejo, was not consistent with ultrasound images from the Planned Parenthood offices in the Orange and San Bernardino counties. Thereafter, during cross-examination, Owens testified for the first time that her appointment was actually with Planned Parenthood in Los Angeles. When asked during cross when she went to Planned Parenthood in Los Angeles, she stated, exactly when I said I went, July 2. That testimony conflicted with her deposition testimony when she stated she had not changed the July 7th date on the Planned Parenthood sonogram, and her testimony during direct examination that the ultrasound was conducted at the end of June. There was testimony presented during the June 10th hearing that Planned Parenthood requires patients to provide identification and does not allow anyone to obtain services anonymously. Respondent did not take any steps during direct or redirect examination to address Owens's false or inconsistent testimony. The discrepancy between the date she testified to during direct examination for the ultrasound, the end of June, the date she stated during cross-examination, July 2nd and 7th, and the date she testified to during her deposition, July 7th. Violations related to respondent's pursuit of meritless claims, false information in an affidavit, and presentation of Owens' false testimony in changing version of events. Based on the conduct set forth above, respondent violated ER 1.3 by failing to act with reasonable diligence in representing Owens by asserting or controverting issues when he did not have a good faith basis in law, and fact for doing so that was not frivolous, and by knowingly failing to take reasonable remedial measures when he knew that Owens intended to engage in, was engaging in, or had engaged in criminal or fraudulent conduct related to the paternity case, by knowingly disobeying an obligation under rules of the court, by engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation, by engaging in conduct prejudicial to the administration of justice, and by knowingly violating any rule or order of the court. The non-meritorious appeal. All allegations, yeah. On September 5th, respondent filed a notice of appeal regarding the order application of attorney fees and costs. On September 9th, respondent filed an amended notice of appeal on Owens' behalf. On November 14th, respondent filed an opening brief with Division 2 of the Court of Appeals, which included non-meritorious arguments. 1. Respondent falsely asserted that Judge Mata ordered sanctions under Rule 26.
Hey, Rule 26 one long time, motherfucker.
Respondents set forth scenarios that were not based on facts, so they did not have any bearing on the propriety of the fees awarded. Respondent failed to meaningfully challenge Judge Mata's findings of fact. And D, respondent's position on appeal was unreasonable, in part because his Rule 26 argument was not grounded in law or fact.
Say Rule 26 one more time, motherfucker.
And his assertion that Judge Mata was biased and committed structural error failed to meaningfully address her rulings and ignored applicable law. On March 28th, Division 2 of the Court of Appeals issued a memorandum decision denying Owens' appeal. The Court of Appeals memorandum decision stated in part, "We note that a significant portion of Owens' appellate argument relies on her incorrect assertion that the trial court ordered sanctions under Rule 26.
Say Rule 26 one more time, motherfucker.
The court expressly awarded attorney's fees and costs under ARS 25-324 and 25-415. None of these scenarios posited by Owens have any bearing on the propriety of the fees awarded in this case, as that determination must be based not on conjecture, but on what actually occurred." The Superior Court also concluded that 25-324B applied because Owens had provided false testimony as to the viability of the pregnancy and had sent Eckert a letter prior to her deposition that indicated her intent to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated. On appeal, Owens does not meaningfully challenge these Superior Court findings, but instead argues 25-324 does not apply in paternity cases. Section 25-415 states that the courts shall sanction a litigant for costs and reasonable attorney's fees incurred by an adverse party if the court finds the litigant lied and did all the shit she did. We don't have to read all of the appeal. Blah, blah. Okay, so the court found Owens' appeal was unreasonable and it was not grounded in law or fact, and the bar is holding him accountable for that. Violations related to the non-meritorious appeal. By engaging in the conduct set forth above, respondent violated the law by failing to act with reasonable diligence in representing Owens, by asserting or controverting issues on appeal when he did not have a good faith basis in law, in fact, for doing so that was not frivolous, and by engaging in conduct prejudicial to the administration of justice. Oh, we finally reached the end. And then after this is all the exhibits, and they're pretty terrible. This is his blog post, and then it's sealed because it was, the judge said don't post them. More social media posts. Annoyingly, but not surprisingly, Mata screwed up the form of final judgment. It doesn't contain stuff required by the rules. Shocker. We could ask her to fix this, but that would be a waste of time. He's so snarky. He's like a snarky Gen Zer, isn't he? It's very strange for a grown man to act like this. I showed you Exhibit C already. Let's see. What's Exhibit D? The warning? Because this one was pretty bad. Yes, the warning. And it was in bright red. Public warning. Judge Julie Mata. Warning. Do you have a family law case in Maricopa County Superior Court? Is your case currently assigned to Judge Julianne Mata? If so, please read this extremely important message. If your family law case is currently assigned to Judge Mata, you should immediately ask for your case to be reassigned to a new judge. And I mean, he just goes on and on about how she's unethical and all this other stuff. Terrible. Just awful. Exhibit E is, the false affidavit. About when she went to Planned Parenthood. Still scrolling. Okay, that's it. We're done. Excellent. Well, to end this video, I'm going to play for you a little song that maybe you haven't heard in a while. And that song is called Tramp Stamp Lawyer.
You know that lawyer? Oh yeah. He's an experienced liar. Oh yeah. He's got a DUI, baby, and a bunch of old ladies with tales to tell. Do you need a lot to save the day? Do you have a problem that should go away? It's just $50,000 to retain today. Tramp stamp a liar. Oh yeah. Oh yeah. Internet lawyer. Oh yeah. Tramp stamp lawyer. Oh hell yeah. thedirty.com to lie about teens and even their moms. There's a string of suicides, ruined lives. Don't get fucked, special ed says mine. Trump stamp a liar, oh yeah. Discriminate lawyer, oh yeah. Hashtag a lawyer, hey yeah. Did you go out on an NFL player? Did you blow your chances with shady behavior? Did you stalk and lie about a couple of babies? Call Trent Stamp lawyer, he likes crazy ladies. You've never read Emotion, Life is your job. He'll write in rainbow markers and fucking blame them. Yikes, Texas yuck. Motion denied, just bad luck. Oh yeah. Internet lawyer, oh yeah. Trump stamp lawyer, oh hell yeah. Oh yeah. Hashtag lawyer, oh hell yeah. Do you need a vote to save the day? Do you have a problem that should go away? It's just $50,000 to retain today. Trump stamp a liar, oh yeah. Oh yeah. Internet lawyer, oh yeah. Trump stamp lawyer, oh hell yeah. Oh yeah. Hashtag lawyer.
Legally, I know it doesn't make any sense, but it's irrelevant. I go
It's
on.
not irrelevant.
It is
You know
absolutely, no,
That
it
is
is.
not irrelevant. You know it.
Hashtag yikes, Texas yuck. Motion denied, just bad luck.
Can I sue you for that? Can I sue you for that?
I think what you do is reprehensible. I don't like it.
Stamp lawyer, oh hell
Can I sue you for that?
oh yeah. Hashtag lawyer, oh hell yeah.
Can I sue you for that?